Welcome to channel AMEC, your insight to the Australian visa system. Good day everyone, my name is Carl Young, your online YouTube visa consultant. Are you interested about migrating to Australia? Why don't you consider to subscribe to my channel and turn a little bell on the side, so once we have all the updates and news, you'll be the first one of getting the insight. In this video today, I would like to take you in the detailed regulations. Now, I've been, not commonly be requesting on this, but some of the viewers and fans would like to actually know what actually the law is all about for subclass 485. Obviously 485, it's kind of very easy understanding visa. It's a graduate work visa, but it doesn't come with two different streams, and sometimes it really confuses people with what the Australian study requirement is and when do we have to get things ready, because some people, they just not get ready and they lost the visa, pay the money and receive a refusal. Unfortunately, that's not what we wanted you to end up with. So I'm taking you into the deep of the regulation and going through every single clause today to actually understand fully. And obviously, by doing so in the YouTube video, if you don't understand, you can have a pause, rewind, rewatch, and you understand fully, so you don't get into a trap getting your visa refused, rejected, and paying more money for legal service and professional to appeal, and perhaps losing the opportunity for skill migration further on. Now let's jump in there and have a look. So make sure you subscribe, and if you like my video and channel, share with your friends. Okay, now the subclass 485. It's very commonly known. It has a name of temporary graduate, so very easy understanding. Now, a lot of people only read about this. Now, people ask me, how do I get this link? How do I read all this stuff? This is actually a digital library that all the immigration visa professional or consultant will require to subscribe, because they change all the time. See, the problem is the law for immigration changes and updates all the time. It gets really confusing at the end. So then Australia is quite smart at creating a digital library where we are looking at this piece of law. Is basically very updated one. It only came out 13th of November, which is only a few days ago. So it's very updated. You make sure that we are looking at the current one. The first thing we need to know is when I click on this is so-called the Schedule 2. We need to check out the Schedule 1, because Schedule 1 will then qualify whether your visa application is valid or invalid. If you lodge an invalid visa, which obviously, it's invalid, it doesn't work at all. So the first thing is we go into the validity part of the law. It's at item 1229, as you can see here, and it says the first thing is you need to go through a proof form. Now, we don't need to go through this legislative instrument, because the proof form nowadays is utilizing IME account. So make sure you click on the right one. You don't click on the business visa and apply for a travel visa. That's not gonna work. So you gotta click on the right one. I don't think anybody will miss that one. And the second most important thing is, well, make sure you pay. That's what the government want. That's how the government make money anyway. So you can see the charges is different. Now you can see there are two, because they are these are the old ones. Nowadays you're paying for this one. So the first one is it's the old days outdated information, but I am pretty sure now they're all paying at this point, because we have just submitted 485, and that was the visa application charge. Okay, now coming down here, if you don't meet this requirement, blah blah blah, for member of family units, then you need to pay a second installment. Or basically the second installment here is a nil. Well, if it's a nil, why do they even mention it? anyhow, that's how the law works. Anyway, now number 3 is coming into a little bit more complicated. So let me read them out. So you can see that the AB is gone. Why is that? Because it's redundant and it's the old law, so they repealed it. So it's no more 3A, 3B. They jump straight into 3C, and there's no D and E. Anyway, it's all gone. It's the old one. It's gone. So now we only have 3C. The application must be made in place in a manner if specified in Minister the legislative instrument. Again, that's copy of what we have already read up here with the same form. Following applicant may be in or outside of Australia when making their application, but not in immigration clearance. Now, bear in mind the definition of immigration clearance, meaning that you're at the airport. You're still not even clear at the airport, so you cannot be at the airport when you lodge this. Now, the F is the following applicant. Number 1, the applicant claiming member family unit of person who is having satisfied primary criteria holding the 485. Okay, that's the 485's full name, 485 visa's full name. An applicant who made application during concession period. Now, concession period is during, I think it's Feb 2020 until November 2020, where these 485 applicant or potential applicant or candidates were affected because they left Australia, and they can't generally in the past 485 visa can only be lodged validly onshore. Now, because they were asked by the Prime Minister to leave Australia due to COVID control, so they lost that right. So what they're trying to say here is that if you're in that situation because you had the right to lodge 485, but then you are not in Australia, so there's a concession period. Who is not applying for second, the 485 visa, or third, the applicant who must make in otherwise, or the applicant must made in Australia. Okay, so that's what they're trying to say. So only if those people who were affected in those concession period, you can lodge offshore. That's what they're trying to say here. Applicants seeking to satisfy primary criteria must nominate only one stream. So it's either gonna be the graduate work, graduate temporary, or the PSW. Okay, so everybody is quite familiar. I've done a video on that one. You might want to go back in. Later in this video, we will review that in the actual law in the Schedule 2. Applicants seeking to satisfy primary applicant for a graduate work stream must nominate skill occupation. So of course, that means if you're going to go through graduate work, you're required to go through skill assessment, and those occupation has to be in MLT SSL. Now, don't know when they're gonna change that, but at the moment it's MLT SSL. Applicants seeking to satisfy the 485 visa PSW must hold a student visa that was granted on the basis after 5th of November 2011. Okay, and that was the first student visa, and must hold that visa after 5th of November. And the applicant seeking to satisfy grant of second in the PSW must hold a 485 visa in the PSW stream. So that means the graduate work stream does not have the right to extend for second or third 485 visa. So that's why people ask me, why are you promoting bachelor, or what about those cookery courses? Well, they got disadvantages, because if you study those one, first of all, you need to go through the complex skill assessments, and you don't have that extension, the right of extend your 485 visa, because just don't have it. They don't have that right there. Okay, now number 4 is the most important part here. When you're lodging 485 and meeting that validity, you need to meet one of the following. So you must hold eligible student visa, of course. So eligible means, well, it's a visa that's, you're studying. Some people, they're holding student visa, but they're not studying. Okay, so for example, they are the dependent. So of course, the dependent cannot lodge 485 because he or she was not the one actually studied or graduated from the course. Applicant is outside Australia when application is made and the applicant has held an eligible student visa. Okay, so one of the following. Okay, make sure this is one of the following. It doesn't have to be meeting all of them. Okay, so this is for the affected people on that concession period. And then number 3, applicant must hold a bridging visa. Either it's going to be A or B. It was granted on the basis of valid application. So that can be, some people are lodging for a visitor extended visa for graduate purpose, and during the time the visitor visa might not have been granted. They are in a waiting period for visa to be processed, so they are on the stage of bridging visa A or B. They'll be eligible to actually lodge 485, and in the condition that they have held eligible student visa at any time, a period 6 months ending immediately before your application. So, meaning that the time of lodging a 485 visa, the system, the law is going backwards 6 months, checking out whether or not you were a student visa holder. If you were not student visa holder, then you cannot lodge 485 visa. So obviously the rule of thumb is once you graduated, you should go to your student center and obtain a document called letter of completion. Now it will indicate your course completion date. Now the course completion date counting 6 months forward, that is the required period you're required to actually lodge 485 visa. If you haven't lodged that within that period or that window of time, then you lost the right for 485 visa. You can't. If you lodge it, 6 months and 1 day later, then that visa will be invalid. Okay. So that's how it actually works. Okay, and number what is it? 1A, 2, and 3. You can see how the law has been evolved and changed many times. Okay, the applicant must hold substantive visa. That means any visa. And held eligible student visa anytime 6 months period immediately before. So again, going back to the scenario that I've just described, you graduated, but your student visa almost expired. You lodge a visitor visa for graduation purpose, and the visitor visa granted very soon. So it granted within a week. So obviously you then hold a substantive visa, and within the lodgement of your 485 visa at the time, counting 6 months backwards, you were a eligible student visa holder. So that is fine as well. Okay, number 4, the applicant must have taken under section 36A, 36A, CD 36379C of the Act notified tribunal set aside. So what is this? I don't understand what it is. Okay, so some people they lodge a 485 visa and they get rejected. They appeal. And they won the appeal through AAT, and that's going to sections 368C and 368D and 379C. And the application of the appeal actually set aside and sent back to immigration. Then this clause will trigger, and obviously you will be deemed to have that 485 visa redeemed. Okay. Number 5, the applicant holds 485 visa in PSW stream and is applying for 485 PSW stream extension, so second. So that's another way. The applicant seeking satisfied primary criteria to grant must be less than 50 years old. Okay, so that's for the Schedule 1 now. That's not the end. We need to go back to Schedule 2. So what we have just reviewed is the validity of a visa application. We are only talking about in these conditions that we have just mentioned, and you lodge your 485 visa, you will have a successful lodgement, not a successful grant of visa or approval, only lodgement. Now let's check out how the visa can actually be granted. So that's in Schedule 2. So let's go back to our legend. Now 485, you can see there's an interpretation. Now we don't need to interpret this. Everybody will know what degree, diploma, and trade qualification will be. We'll go through some of the Australian study requirement. So again, the brief is saying that there are 2 streams. There's a graduate, there's a PSW stream, and there's member of family unit can be allowed in here. There's a common criteria, means that it's for the 2 different streams. there are some common criteria. So either of the stream has to meet all of these common criteria. So if you have obtained 476 before, you cannot lodge a 485 visa. Okay, so you cannot have those for nationality of those engineer people graduate overseas, not in Australia, but with the diplomatic right, they can actually apply for 476 visa. I've actually done a video on that one. If you wanted to check what 476 is all about, just search in my channel, you'll find that. Okay, and the second one, has not previously held 485 visa in graduate work stream. Okay, so you cannot lodge two graduate stream, okay, because you cannot extend it. And number C, unless the applicant has nominated PSW in the application meet the requirement of 485.232 and 485.233, has not previously held 485 visa in the PSW stream. Okay, so again, that's basically saying you cannot do it twice. Now, bear in mind, this means it has to be the main applicant. Okay, if you were a holder of a secondary substantive entry of the another 485's primary, and you're a secondary visa holder, and you complete a study while you extend another student visa, you will still have the right to do your 485 visa. Okay, and has not previously held two 485, so you cannot have two, so you can only extend once, not twice, only once, and it depends on the area or where you are. Okay, some regional area can allow you to extend with 2 years, and most of regional area can only allow you to extend with 12 months additional to the already 2 years PSW given to you. Okay, now 485.212, the applicant must accompany with evidence of language. All right, that legislative instrument, we can actually go, I think it's this one. Okay, now it's quite easy to understand. Now it basically says your IELTS needs to be at a certain level, which is right above me, and IELTS overall 6, nothing below 5. Okay, if it's gonna be OET, bad luck, you gotta get OBs, which is harder than getting 6 in IELTS. You can take TOEFL, and most of the people will actually take PTE. So 50 overall, but nothing below 36. So that's basically what they are trying to achieve here for that language thingo, and has achieved within the period specified and administered in the instrument score, which is just what we have just seen. An applicant hold passport type of specified the Minister of Legislative Instrument. Now those passports were the US, UK, New Zealand, Canada, Ireland, and they are deemed not required to go through an IELTS test or English proficiency test. Okay, 485.213. When the applicant was made, it has accompanied with evidence of the applicant. Well, duh. I mean, how would you lodge an application without applicant? Anyway, each person had included who is at least 16 years of age had applied. Doesn't have to be receiving the actual AFP certificate, but you need to have already applied for AFP. If you haven't done so, you apply 1 day later than the applications, then you will be rejected. Okay, and check during 12-month immediate before a day application is made. So this is actually very important. A lot of people got rejected. They apply for the visa and they haven't accompanied with the AFP application, which is the police check. Then I'm not too sure why they do this, because a lot of other visa they can lodge on shore, they're not required for AFP before at the time of the application. So anyhow, but this, I think it's I'm not probably a trap, Do they like to trap you? I'm not too sure. 45.215, when applications made, accompanied with the applicant's adequate arrangement of health insurance. So you need to demonstrate that you have purchased a health insurance for the purpose of 45 visas. If you don't know what that is, very easy. Just go to any shopping mall, shopping center, and find an insurance company. Tell them, look, I'm about to apply for 45 visa. What insurance should I buy? They will tell you. Okay, now the rest of the stuff is public interest criteria, meaning that you need to go through your health checks, and make sure you haven't done any bad thing with your character and things like that in your during the time while you're in Australia, and that's probably why they want you to check your Australian police certificate there. Now, jumping into, this is 45.21a. Let's have a look. Granted, the visa will not result either a number of 45 granted new financial year exceeding maximum number, so there's no quota. That's what I'm trying to say. A number of visa particular class granted financial year exceeding the maximum number. So again, there is no quota. That's right. I'm not too sure why they put this clause here. Probably they are controlling how many people can actually graduate. Can they do that? I'm not too sure. I haven't seen actual they done anything or anyone had any problem with this clause before. Okay, now first of all, the first stream criteria for gradual work stream. So basically, gradual work stream are people who had either study or came to Australia to study on November 2011, and they have came back for further study. Then they will end themselves into this graduate work stream. So they must satisfy Australian study requirement. Let's check out what Australian study requirement is all about. So where is it? Okay, here we go. That's the law. The Australian study requirement says a person satisfied Australian study requirement if the person satisfied minister has complete one or more degree, diploma, or trade qualification award by Australian education institution, reasonable course or courses. So that means it can be one course or two courses, okay, or multiple courses. They are registered courses. That's pretty sure, because either if you're not getting the registered course, some people does this. They enroll one courses and they go and study for another courses, which is not a registered courses. You cannot take a graduation of an unregistered courses and apply for the visa. So that's pretty sure, very easy to understand. And the completion have a total at least of 16 calendar months. Now 16 calendar months will equivalent to 4 semesters. So 4 months per semester, and they will complete a result of at least 2 academic year. Now, academic year is not financial year. It's not a natural year as well. For example, some university does have trimesters. They utilize trimesters. So you got 3 semesters in a year. So by means of 16 calendar month, they can actually squeeze the 2 years study into 1.5, for example, and that will still equivalent to 2 academic year. So that's what they're trying to say here. Well, and the study was instructed in English. Well, pretty sure they will be taught in English. Not too sure if they were international students coming to Australia and study courses in other language. I wonder how that would be. Okay, and E, that the applicant undertook while in Australia. Well, pretty sure as a holder of visa authorized the applicant to study. Now, there's obviously there are people who will start saying, what about the pandemic? We've been holding a student visa, but we study online. Now, there is a concession period, and that's where the concession period that you have saw. And so that as long as you study online while holding a student visa, you are considered undertook in Australia. Okay, so that's where you need to find that out. So you need to make sure, even though if you study online outside of Australia, you still hold an Australia visa, which is student visa, and that will get you as in Australia. So that's why they're trying to explain during the whole thing. Okay, in this regulation, completion in relation to degree, diploma, and trade qualification must have met academic requirement for its award. That means you have completed, you got graduated, you got graduated certificates. So that's what they're trying to achieve here, and these are the actual law and definition for the Australian study requirement under regulation 1.15F. Okay, now let's go back to schedule 2. Now, so we understand the graduate visas, graduate work stream. This is the item schedule 1. Okay, so we got that done. Again, 485.222 reiterate Australian study requirement. Each degree, diploma, trade must satisfy Australian study requirement. Again, the same. 223, when the application was made, it was accompanying evidence that a whole assessment of skill assessment. So the skill assessment has to be met, means it's already lodged. You have a skill assessment receipt. Okay, now if you don't have that skill assessment receipt, meaning you haven't lodged it, then your 485 visa will obviously fail. Okay, so that's what they're trying to say. And 224 is at this end, the skill of applicants' nominated occupation has been assessed, and during the last 3 years by assessing authority as suitable for the occupation. Okay, if the assessment is expressed to valid particular period, the period has not ended. If the applicant's skills were assessed on the basis of qualification obtained in Australia while the applicant held a student visa, the qualification was obtained as a result of a studying a registered course. What does that mean? Okay, why are they inserting this? Now, for example, you were an engineer before, but then you study engineer outside of Australia, but then you came to Australia and study IT. Now, instead of having your IT background skill assessed, you're trying to be smart enough, you assess under your previous engineer qualification. Obviously, your skill assessment will probably be successful. But then if you lodge that skill assessment under 485.224, they'll come back with the clause, subclause 2, and come back to you saying, look, I understand you were an engineer, but this engineer qualification or skill or occupation was not actually done while the qualification obtained in Australia. Then obviously that cannot be counted. You see what I mean? But another scenario. Now, if you had studied and you were an engineer, and that engineer was a result of your study 10 years ago in Australia, then you went outside of Australia and work, and you came back and studied IT, for example, and you graduated, and then you submit a skill assessment for your engineer occupation. Now, in this case, that will meet the requirement. You see what I mean? Because that engineer skill assessment was as the result of your qualification obtained back in Australia, or 10 years ago, can be 20 years ago if you had. So that's another scenario there, digging into the detail of the law. Now, finally, let's move into the PSW, post-study work stream. So it's much easier and understandable than the previous stream, because all it does, it doesn't require skill assessment. All it requires is Australian study requirement. So we have done an explanation of Australian study requirement, basically 2 years, 2 academic years, 16 calendar month, and the course has to be registered and resulted in the qualification. So it only has a little bit of addition to here, is that the applicant hold qualification that is kind of minister instrument in writing. Now, what does that mean? That basically discarded diploma and the trade courses. So it has to be bachelor or above. So that's the only thing differences for the PSW there. The institution has to be conferred by instrument writing, so that's registered courses. In the period of 6 months immediate before application was made, or the minister is satisfied that applicant was unable to apply during period of the the paragraph A, because it was outside Australia during a part of a period commencing on 1st Feb to 19th of September. Oh, so I was wrong. So the concession is between Feb and September, not November 2020. So while you're offshore, you still can able to lodge it, but it has to be done within that period of time. Okay, these clauses apply for before the applicant will satisfy certain requirements. So all of this one. Okay, and this clause, the following the 232, held a 45. So this is for second PSW. So if you hold a 45 while you were in regional Australia, you are eligible to lodge for a second 45 visa. Grant of first 45 was based on a study, okay, and you were at regional center, regional area, and that means, okay, declare the application for second with the family together, and obviously you can get that as well. The applicant must have lived in those area. Okay, you cannot be in Sydney, Melbourne or Brisbane, and have been in there for 2 years, okay, and gather work or study, or actually just stay there, you'll be fine. So applicant live only, there's a little different between some regional centers and some regional areas. Most of them will give you 1 year. Some of the very far, for example, Northern Territory will give you 2 year. So it depends on the area where you are. I've done a specific video on that one, so you might want to refer to that. So the last but not the least, 233. This is all about the held 45 visa, first visa, and you made a second visa. Grant of first visa was this is actually the same, the copy of this one. The differences between here is one is a regional center and one is saying designated regional area. So one is giving out another 1 year, as you can see, and the other one is giving out another 2 year. The difference is between Northern Territory or compared with Gold Coast, of obvious that we're giving 1 year. Adelaide, no, that's 1 year. Northern Territory, they'll give you 2 year. So some of the more remote area, they are deemed to have given you more visa time for the second visa. Anyway, so that's, and the rest of it is about family and grant time. So that's about the whole law and regulation of 485 visa, going through all the detail there. If you like how I have gone through all these regulations in detail, well, give me a thumbs up, and whatever the visa type that you want me to go through the actual law, leave a comment right down below. And should you have more query, leave me a comment as well. Thank you for watching, and I'll see you next video. Goodbye.